of Jamaica and before many of the governments in the Caribbean. How many of you know how many countries the university operates in across the world? A wild guess. 1, 2, 3. We operate across 26 jurisdictions. And these jurisdictions include Caribbean jurisdictions in Europe, Africa, and North America. So to us, privacy is a big deal. And we take your privacy seriously, and we take the privacy of the information that we hold about anybody else seriously. Now, every year, we mark February as our Privacy Awareness Month. And during this month, we intensely look at privacy, and we look at all the elements of privacy. And this year, because we've been doing this for so long, we said that we are going to move beyond privacy awareness. That's our theme, moving beyond privacy awareness. What we expect is that you're going to start putting in place good privacy practices in your daily work, in your daily undertakings, and in your daily interactions. And I hope that this afternoon's discussion will be enlightening to you, but also will be entertaining, and you will enjoy some of our prizes, as you've started to already. We look forward to engaging with you even beyond February, because the expectation is that once you've been bitten by the privacy bug, you will continue to use what we've taught you in everything that you do. And always remember that privacy is about respecting the confidentiality of others as much as you want them to respect your own. So again, welcome. Thanks for joining us, and we look forward to the interaction later on.
Thank you so much, Dr. Anglin. So I'm going to take a quick 5 minutes break. I'll open up the refreshment section if anybody would like to grab some refreshments, and then we'll begin with the panel discussion. So I'll introduce the panelists and the moderator, and then we'll jump right into the discussion.
wrong, wish you would understand. I don't wanna lie, but I don't want to cry. Yo, I'm so very weak inside. Oh Lord, don't let me cheat on my girlfriend. 'Cause as far
Dr. Anglin acts as the primary contact for data subjects and supervisory authorities and oversees adherence to the UWI data protection policy and relevant privacy laws. Starting his career at the UWI in 1996 as a computer programmer, Dr. Anglin has held various roles, including positions in the Officer of Administration and Special Initiatives and the Office of the University Chief Information Officer. He is an adjunct lecturer in the Department of Computing at the Mona campus and serves on the University Council of Jamaica's Distance Education Standards Committee. Dr. Anglin holds a Doctor of Business Administration focusing on innovation systems from the University of Manchester, an MBA, and a Bachelor of Science in Computer Studies from the UWI. Throughout his tenure, he has significantly contributed to the UWI's Information Technology Policy Framework, and his post is vital to the university's operations, ensuring all appropriate data protection practices are adhered to. Let's give him a hand. Next up, I'll introduce our second panelist, Mrs. Sandra Robinson Brown. Sandra Robinson Brown is a seasoned risk and compliance professional with over 20 years' experience in the financial services industry, spanning risk management, regulatory compliance, accounting, and operations management. She currently serves as Senior Risk Manager, Risk and Compliance at Chris & Charles Investments Company Limited, where she leads the organization's enterprise compliance framework, including anti-money laundering, data protection and privacy, fraud risk management, and enterprise risk management. Sandra plays a pivotal role in strengthening Chris & Charles Investment Company Limited's data governance posture through policy development, staff training, vendor risk oversight, and regulatory engagement. She also serves as a key liaison with external regulators and data protection authorities. She's presently pursuing a master's degree in general management with a concentration in human resource management at the Mona School of Business and Management at the UWI. Sandra is passionate about translating privacy and data protection from legal theory into practical organizational behavior and public awareness. Mrs. Robinson Brown. Our third panelist is Mrs. Cassandra Lee Masters. Mrs. Cassandra Lee Masters is the IT Service Delivery Manager at Vertis Technology Solutions Limited, where she works closely with organizations to manage and secure their physical and digital IT environments. In her role, she bridges the gap between policy and practice, helping clients translate data protection requirements into clear, workable processes that make sense in real life. With hands-on experience across infrastructure, cloud system, and managed services, Cassandra brings a practical perspective on what privacy looks like day to day, especially in the relationship between data controllers and data processors. At Vertis, whose mission is to enable your best, she focuses on building systems, partnerships that protect personal data while empowering organizations to operate confidently and responsibly in an increasingly digital world. Mrs. Masters. Our fourth panelist is Miss Andrea Holness from the Office of the Information Commissioner. Ms. Andrea Holness is currently the Director of Complaints Resolution and Compliance in the Office of the Information Commissioner, Jamaica. Her role centers on monitoring compliance with the Data Protection Act 2020 and its subsidiary legislation, with a focus on resolving complaints, directing enforcement activities and investigations, and ensuring compliance with international data protection laws, standards, and good practice. She envisions making data privacy and protection compliance a natural ingredient in everyday life, where every person understands the right to privacy. Ms. Holness holds postgraduate certification in Human Resource Development from the University of the West Indies, Mona campus, and in International Business Law and Maritime Law from the University of London in the United Kingdom. Ms. Andrew Holness. And I've completed the introduction for our panelists. Let's move to the introduction of our lovely moderator for this evening, who will be engaging our panelists in this very, very vibrant discussion. So our moderator for this evening is Mrs. Gayan Facey. Mrs. Facey is a records and information professional with over 20 years experience and is former records manager and certified ISO quality management internal auditor for JN Bank. She has served as the Mona campus records manager for the University of the West Indies since October 2019. Mrs. Facey is a strong operations professional with a Master of Science focused in records management and digital preservation from the University of Dundee in Scotland. She's skilled in records and information management, taxonomy development, enterprise content management, knowledge management, electronic document, and records management systems. Mrs. Facey is a motivational leader with a passion for developing people to meet and exceed their potential. She has a solid background with a proven track record in the application of quality management, business process analysis, process improvement, and stakeholder influence to align business requirements with information and records management solution to meet legal and regulatory requirements. Your moderator for this evening. I will hand over to our lovely moderator and our panelists to begin their discussion.
Good afternoon, everyone. Welcome again to this fireside chat. Although there are no bread nuts roasting on an open fire, or I would have preferred some roast corn and some roast jackfruit seed and what else we roast in Jamaica? Cashew and dasheen and yam. But regardless of the fact that there's nothing here to roast, we will still be having a wonderful fireside chat, right? All right. So today we're here with our panelists, and you would have been already been introduced. And now we're going to start off with Dr. Patrick Anglin. Dr. Anglin, can you give us a brief explanation of what privacy and data protection means in simple terms for the layman to understand?
Thank you very much, Gian. So privacy, and when we speak about privacy, we're speaking about data privacy, as opposed to your privacy that you would have if you were asked to remove your clothes. You know, that's not what we're talking about. So that data privacy is your right for your information to be kept confidential by persons with whom it is shared. That's basically it. It's very, very simple. You have a right when you share information with anybody that information is kept confidential by them unless you've asked them to share it or there is another legitimate reason for it to be shared. So that's one. So that's data privacy. Data protection is what the person with whom it is shared puts in place to ensure that the information is kept confidential. So data privacy is your right for it to be kept confidential, and protection is what the person or organization with whom it is shared, what they put in place. That's basically it. Very simple.
Thank you, Dr. Anglin. Now, Ms. Holness, Why are organizations now required to handle personal data more carefully?
Good evening. Hello. Good afternoon, everyone. Thank you for having me, and greetings from my office and the Commissioner. Actually, it's your constitutional right to privacy. So data privacy is actually drawn from the Constitution, and it even covers your right to communication. So it's a constitutional right. We now have an act that requires you to treat personal data exchange between data subjects and data controllers with the utmost care by adhering to 7 standards. Also, globally, you will realize that almost in every country, especially as we become more of a digital village, almost everything is in digital space. So it's not just your rights here within Jamaica's jurisdiction, but globally. So what we are protecting is something that over 178 countries have ratified by international convention as a part of your right to privacy. It's for that reasons that organizations within Jamaica's jurisdiction and the organizations we do business with, and I hasten to add, data controllers, which are both persons, you and I as individuals, legal persons, corporations, businesses, public authorities, every type of government agency is bound by that. So when we talk about data controllers, it could be you having your own company, selling something on the internet, and you have to ensure that once it's within our jurisdiction, you're complying with what the Data Protection Act says.
Thank you, Ms. Holness. So for our students who are from another jurisdiction who study at the university, does our Data Protection Act apply to them?
Actually it does, because they're within our jurisdiction, and I hasten to add that the jurisdiction extends to our embassies, commissions, any part of government where Jamaica law applies. And they actually, part 2 of the Act, which states the rights, talks about the rights of data subjects and others. So, for example, it's really a relationship between a controller and a subject. So you accompany your husband, your child to the doctor. The patient is actually the child or the husband. You are actually on the premise. There may be CCTV. So in that case, you are not the actual person involved in the transaction, but you're present and therefore will be captured under other. And because it's an internationally recognized right, albeit it's a qualified right, because there are exemptions where that can be stood down, it is necessary, and it covers everyone in our jurisdiction, citizen and others.
Thank you very much. Now, Mrs. Robinson and Mrs. Masters, can you explain from your perspective the importance of accountability and transparency in handling personal data in your respective roles, Sandra at Chris and Charles and Mrs. Masters at Vertis Technology?
Okay, good afternoon, everyone. Sorry about that. Now, as for those who don't know, Chris and Charles is an investment company. Its core business is our lending. So we lend. Persons come, they want a loan, so they will come to us. So it is necessary that we collect personal data. You need the data in order to process that loan. So we have to be accountable because you want to ensure that there is privacy with your information. And so when we collect your information, we have to demonstrate that you can trust us with your information. So we ensure that the data that we collect, first we will allow you to know that we are also a data controller, and so we have the right to protect your information. So we have to demonstrate that we are able to do so. What are we taking your information for? We have to demonstrate why we need your information. How are we going to store those information? You know, so those are some of the things that we look at. And so we don't just say the word, so it's not just a policy thing, but we also want to ensure transparency. So we will tell you that in order for us to give you the loan, then we need to verify your information. If you are employed to the organization, we might need to know a background check on you. So we have to go to a data processor, which we will learn further down in our discussion. And so in order for us to get that information, we need consent from you. So we're not just going to take your information, but we're going to pass it around. So it's necessary for us to be transparent, and it's necessary to show you that we will be accountable, not just to you also, but also to our regulators, because as a data controller, we have to go by the regulations.
Okay. Okay. All right. So as data processors at Vertus Technology, we have to also demonstrate, not just claim, but demonstrate that we are handling your data. And when I say your data, it means the data that you give to companies like Chris and Charles, AIM Financial, so and so. So all that information is hosted on systems and different machines. Vertus plays a part of managing those machines and infrastructure on a whole. And so as data processors, as third-party data processors, we also have the responsibility of ensuring that the same trust that you place in Chris and Charles, they can place in us to manage the infrastructure and keep the infrastructure safe. And transparency, on another note, means that Chris and Charles can trust us. So whatever information that we have access to, they know why we have access to it, and the only reason why we have access to it is for the sole purpose of maintaining the IT infrastructure and nothing else.
Thank you very much, ladies. This is an open question to the panelists. Anyone can answer. I may just speak on Dr. Anglin. From your perspective, what does privacy really mean in practice, not just in theory? So, for example, a lot of us go to church. The service is recorded and streamed on YouTube or on some platforms. You see the social media persons taking photos of the congregation, etc. Even here on campus, there may be activities that are happening and we may attend, etc. What does privacy really look like in practice?
Well, practically, I think we have to understand that privacy is a continuum. It means different things to different persons. It's less severe. So, by way of example, let us say that you have a partner and you share a bed with that partner. You sleep together. You might share a secret with that partner, but you would not share that secret with somebody in your workplace. The expectation is that you wouldn't want your partner to disclose that information to anybody, including people at your workplace. However, you may come to somewhere like UWI and you go to admissions and they ask you for your telephone number and your name. Your expectation is that you're going to share that with your faculty. They're going to share that with other parts of the university. So privacy depends on the perspective of, first of all, the data subject, the person whose information it is. And also, it also depends on what it was given to the data controller for. The controller would be the company or individual who determines how the information is used and processed, shared and disposed of. That's really what the controller is. So practically, it depends on perspective. So that's one. Two, when no context is given, so you don't know the perspective, it means that all information must be kept confidential because you don't understand the context. So again, using the same example, you're with your partner in bed and the partner says to you, yeah, I mean, you can't tell anybody this. That sets the context. But if they then say to you, or they don't say that to you, the expectation is it's kept private. Same thing here. You come here and you give, for example, you go to the health center and you give the health center a piece of information. The context is already set. It is your health information, and that becomes sensitive. You don't want that to be shared. However, again, you're in a lecture hall and we have our cameras and we're taking pictures. Context, again, is important. You don't necessarily want the fact that you're sleeping in class to be shared. But if you answer a question and you do well, you want that to be shared. So privacy is contextual, but when the context is missing, it is important to understand that confidentiality is a rule of thumb.
Thank you very much. That is the most simple way, practical way that anybody has ever explained. Just by contextualizing and using the analogy of just the relationship with two persons, it's very profound. Thank you very much. And I know you are an expert at providing these practical examples. Thank you very much. All right, so I'm going to throw some more questions at you, Dr. Anglin, and these are specifically related to your role as the University Data Protection Officer. Now, who is a data subject?
A data subject is anybody who can be identified from the information that is in the possession of anybody else. That's really the data subject. And by the way, that data that we're talking about, it doesn't have to be a name or a telephone number. It can be a description. Again, the subject is the person who is identifiable from the information that you hold. That is the subject. And it has to be, the subject has to be a real person, right? Not an avatar or an NFT. A real person. And in some jurisdictions, not in ours, in some, has to be living. In Jamaica, though, even if the person has died, and the person has died less than 30 years ago, they are still considered a valid data subject, and therefore their information must be kept confidential. So the data subject, again, is anybody whose information you can use to identify them. Anybody. Individual. Not a company, not a car, not a house, a person.
So, as the data protection officer for the University of the West Indies, what is your role?
All right, so the DPO, and I'm going to use the term DPO as an abbreviation for data protection officer because it's easier to say. The DPO is the compliance officer. What does that mean? It means that my role is to oversee the organization and its effort to ensure that it's protecting the confidentiality of the information that it processes. And processing means anything. It means what you collect, what you store, what you use, what you add to. In fact, if I hand you a piece of paper to throw in the rubbish bin and it has personal information on it, you are processing the information. So it's actually anything that you do. So my role is to ensure that the university complies with the strictures of good privacy practices. Some of those are legal and they are related to our supervisory authority, and that's another term. That supervisory authority is a generic term across the world for information commissioners' offices. They're not called that in every jurisdiction, but the term supervisory authority is a term that is used all across the world. Some countries call them offices of information commissioners, some countries call them ombudsmen, Some countries call them data protection commissioners. Doesn't matter. The supervisory authority oversees what is happening. And my role is not only to oversee compliance of the university, but also to liaise with the supervisory authorities. So that's another role. So the first one is to look at compliance. So I am the person you come to when you believe that there is a problem. Secondly, when the information commissioner believes there's a problem, they also come to me. But the third thing that I do is things like these. I build awareness. You must understand the university, the controller, and also what we're doing with your information. Now, that understanding drives several things. It first of all drives your becoming vigilant in terms of what is happening with your data. That's the first thing it drives. The next thing, it manages expectations. Because many persons believe that just because we have a data protection office and officer, and there is a superstructure, many persons believe that their information should be retained in a single location. So a part of my awareness sessions is to say to persons, students, staff members, no, the university has what is called a legitimate interest because we're running a school. So therefore, we have to share your information. We have to share it amongst ourselves. We have to share it with regulators. We have to share it if there is a criminal investigation. And if you fall ill, we have to share it also in your vital interest. So my role, I just went through 4 things, right? So the first one was compliance. Remember compliance? The next one, what was the next one? Awareness. That was the 4th one. What was the 2nd one? So the 2nd one, so the next one was ensuring that I liaise with the supervisory authority. Class, come on, class. All right. All right. The 3rd one was really about awareness building, eh? No, sir? And there is a context to that. Now, it is important that we understand that any organization and every organization still have their roles to play. We're running an organization. Chris and Charles is running a business. So is Vertis. And we must understand that there is a balance between what they do in terms of what they are expected as a business to do and how they're expected to manage our information. I'm saying a lot, but I hope you're getting what I'm saying. Okay.
In your answering the question about your role, I hear coming out some of the misconceptions about your role as the data protection officer. So in that light, what are some of the misconceptions about the UWI's Data Protection Office?
Well, one of the biggest misconceptions come from our students. Our students expect us to intervene, for example, in academic matters. So they didn't like how they did on their exam. And they expect us to intervene and pull the exam script and say, no, this is how it should be. But that's not how it works, eh? In fact, as our regulator will tell you, there is actually an exemption in the law in respect of exam scripts. Yes? So while exam scripts contain personal data, you don't have a right to see the script. You don't have that right. The exam script specifically. So that's a common misconception. Another one comes from fellow staff members, colleagues. They expect the DPO to do everything in respect of privacy. They don't believe that they have a role to play. So, as colleagues, I have to say to my own colleagues, listen, privacy is everyone's responsibility. And therefore, it is not the DPO's office which is supposed to be enforcing these things. It is the institution which is supposed to be enforcing these things, and staff members are supposed to play their role. Our job is to check for compliance. So we do audits, we do education, and we also impose penalties, which is the least favorite part of my job. I am authorized to convene a disciplinary committee through the university registrar or campus registrar. And that disciplinary committee can actually lead to persons being disciplined as far as being delinked from the university. If you're a staff member, it means that you lose your job, and if you're a student, it means that you can be expelled. So there are many things that the DPO does, and the biggest problem that we're having as an office is the thinking of many persons, because the regulations or parts of the act are not yet in effect. They believe that they're not supposed to do anything. That's one. But also, another thing is that they think that there are no consequences. Because consequences flow from two levels. The institution has its own consequences, but also the government, through the regulators, through the supervisory authorities, have put in place consequences. Those are not yet in effect in some jurisdictions. But internally at the University of the West Indies, we do have consequences to behaviors. And many persons, in fact, before I finish that statement, the last session that we had with one of our integral units, when I said to persons, you must report when an incident occurs because it might be a data breach, somebody looked at me and said, but that's like scoring an own goal. Meaning that reporting on yourself doesn't benefit you. It does, in fact, benefit you because it prevents me from taking a particular kind of action against you, but it also protects your institution because it then allows us to make a proper report and filing to the authorities so that they themselves can take the appropriate action. I've said a lot again, eh?
Whole lot. So, can you arrest me if I breach?
All right, so I don't have the powers of arrest, fortunately, yeah? But, so, I know that we're streaming across the Caribbean, so I'm going to restrict my comments to the Jamaican space. So, for my colleagues in the Eastern Caribbean, please forgive me. In the Jamaican space, we have section 68 of our act, and correct me if I am incorrect, Madam Compliance. 68 of our act, and it's in part 5, it has not yet been brought into effect. It's in effect, you see? So, there are two components to it. One is a criminal component. It means that if you are found to be a part of a breach, you can, in the parish courts, be imprisoned for up to 5 years. And this is the Jamaican system. Again, pardon me, Eastern Caribbean. And in the Supreme Court, you can be imprisoned for up to 10 years. So there is a custodial component. So that's one. So take the breaches seriously. However, there is another component where you can be fined. And in the lower courts, we're talking about the parish courts and resident magistrates courts for the persons in the Eastern Caribbean. You can be fined for up to 5 million Jamaican dollars, or at the Supreme Court level, the fine can be imposed by the judge. So it is a very serious thing that we're talking about. Now, across the Caribbean, there are similar. So for Barbados, there are similar provisions in the Barbados Act. There are similar provisions in the Act for Trinidad. There are similar provisions in the Act for Antigua, and I'm speaking to our campus countries now. And there are similar provisions in the Act for other jurisdictions which have St. Lucia, for example. So we have to be very careful about how we look at not enough consequences. Now we thank the supervisory authorities for not coming down heavily on controllers like ourselves, because we know that we can be fined although in some instances it's not yet in effect in some of the jurisdictions. But we must operate as if it is. You must practice, because if you don't, then you're going to slip into practices which lead you to fall in non-compliance with the law. So how many persons here understand what I said a while ago? You understand, right? It's very serious. Tell your friends. Those online, spread the word for me, please. It is very serious.
And with the seriousness of those penalties, it means that we need to change our outlook and change the way we operate in our various both personal and professional spaces. So what are some of the challenges that you face in getting especially staff to change their behavior or adopt best practices around handling personal data?
I feel like you're picking on me again. All right, so I think the biggest challenge that I face, and we're talking now about a very sophisticated institution, but let's put on the table. The biggest challenge is that persons think they know it already. That's the biggest challenge. Persons think they actually know it already and they're doing it already. Now, that is a challenge, and it's a fallacy. You actually don't. You actually don't. And that is why we have purposely taken privacy awareness for a long road trip across the whole month of February. Especially those in IT, and I'm coming from IT. The IT guys say they know this already. And when you kind of ask them some questions, it is good for cybersecurity and information technology security, IT security. But some of the practices are not necessarily the practices that we speak about in privacy. So that's the biggest challenge. Persons think they know when they don't. You only ask for the biggest one, right? But the one right beside that is persons think they don't need to. Even if they don't know, they don't think they know, they don't think they need to. Because they've been doing this the same way for 5, 10, 15, 20 years. So what? So what? In fact, the biggest challenge we find from those people is that they are not interested in learning because they don't think they need to.
You have a very hard road ahead of you and a very interesting road ahead of you, because I know, based on my experience, the Data Protection Office has done a lot of training and awareness. Every February, we have a long, a whole month of activities and training and so on, which I believe you are really trying to not only build awareness, but to also change behavior. And having done this a couple of years now, how does training and awareness, have you seen training and awareness as a contributing factor to reducing the UWI's risk of a personal data breach?
Definitely. Definitely. In fact, so as the DPO, I sit on University Risk Management Committee, and as a part of my observation, persons are weaving privacy into their ways of working. So we call those our privacy wows, yeah? So they're weaving them in. And we deliberately did not put out a set of standard operating procedures for specific privacy issues. What we did was we broke the university up into what we refer to as 6 working groups. And these working groups represent the different business areas of the university. And so let me name them quickly. Campus records, which what we're talking about here largely is about record keeping. And everything at the university is a record, including your email. So that's our first working group, because we recognized that we had a problem. Then we went to HR, because that's where onboarding takes place. That's where training and development takes place. But that's also where the discipline comes from. Then, of course, we're in the age of innovation. So we had to go to ICT. That's our third working group. And that working group was really about ensuring that the tools that are used to manage data are kept secure. So our three so far: campus records, HR, and ICT. And then much of this is being driven from the law. In fact, as early as 1948, in the Universal Declaration of Human Rights, Article 12, is when privacy was embedded. So we recognize that the laws have evolved and they have caught up with us. In fact, many of the laws have been translated to principles. We have the generally accepted privacy principles. We have the fair international practice principles. And all of those things are a part of the rubric of privacy. So the legal bit was important. So campus records, HR, ICT, legal, 4 working groups. But then we recognize that the university revolves around the registry. Everything goes through the registry. Academic support goes through registry. Training goes through registry. Every piece of record keeping goes through registry. In fact, our records goes through registry, and HR goes through registry. So we had to have a registry operating working group. And all those working groups work together. But you recognize that we're a big institution. We span a large swathe of countries, 26. Our footprint is humongous. So there needs to be a way to communicate information to people. And our final working group was our Marketing and Communications Working Group, or M&C. And that working group helped us to put together the communication plans to make sure that all the touch points are seen. So that is how we actually did it.
Yes, you did it, you could it, and you could it how you did it, and it is working. I just want to commend you and your office for the awesome job that you're doing in building awareness. And it is evident in the ways people are now operating and the questions they're asking.
But
yes.
I'm not finished, because that's how we started.
Okay.
That's how we started. So we did that deliberately because we had to embed. This year, we are starting the effort to move beyond privacy awareness. This year, we're moving beyond privacy awareness. So you see, at the end of February, university people are going to see some new things coming out. We're now going to have serious SOPs. So before now, we only had the SOPs procedurally for those 6 working groups. So now, we're going to get serious. We're going to start talking about data subject rights. And what are the SOPs for those things? We're going to start talking about not just our privacy impact assessments, but our data protection impact assessments, which are statutory requirements. We're going to come with those. We're going to come with some other things. Confidentiality SOPs. Specifically, when somebody is onboarded, not only do they sign a confidentiality agreement, but we have to have escalation pathways for those things, depending on the kind of personal data that you manage. Because there are 2 categories. There is personal data, and there is a special category called sensitive personal data. So we're going to come with those SOPs as well. Now, we already have incident management, but we're going to come with escalating incident management SOPs, because most jurisdictions only give us 72 hours before we have to report to our supervisory authority. So we're going to come with escalated incident management SOPs. But organizations can't do those things at the outset. And that is why we didn't start there. Because the theory, so when you read the theory and when you do these certification exams, all of these things are there. But these things have to be culturally appropriate and specific to your organization. It's not that we didn't know them, but we weren't ready. I think we are ready now. That's where we're going.
Thank you very much, Dr. Anglin. Can you put your hands together for Dr. Anglin? I will now pose some questions to our lovely representative from the Office of the Information Commissioner, Miss Holness. Welcome. Now, what is a data controller and what is its role in the data protection context?
Okay, so a data controller is a person, meaning a living person, you and I, or a legal personality, businesses, corporations, or public authority under our Act, all of whom process personal data. Dr. Anglin talked about processing from the moment you have something in hand. So I often say to persons, once you're processing, once you've received an email, that email address from the sender has their name in any shape or form, you're poised for processing personal data. The Act talks about obtaining, collecting, carrying out several operations, automated or otherwise. And I just want to dispel one misperception. Physical records are actually containing personal data. I think because our act is called Data Protection Act, people tend to think of data in digital space only. So, for example, you as a data controller, you have HR records, you have paper records. There are some professions where you must have the hard copy of the document. It has personal data there. It also is subject to the 8 standards and everything else in the Act. So if you look in the Act talks about 2 things as its main focus. The general principles to ensure proper processing and treatment of personal data belonging to an individual, and our office providing transparent oversight for those practices. So the data controller actually is our target at the OIC to ensure that they have systems in place, appropriate measures to protect you. Because at the heart of all that we do, it's for your protection, you and I as individuals.
And the next question, and you mentioned it, is processing. What is a data processor and what is the processor's role in the data protection context? And then I want you to juxtapose them and tell me if data controllers are considered data processors and are data processors data controllers, so we can get that comparison and that contrast as applicable.
So anybody who's good at math understands subsets and Venn diagrams. So all data processors are data controllers, but not all data controllers are processors. And it's simply in the Act speaks about a data processor being anyone who processes data who is not an employee of the controller or their agent. So a simple example, your students, you are offered health insurance as part of, if I remember correctly, when I was here, we had health insurance. So that health insurance may be provided by Sagicor. So Sagicor has to comply with everything that the Act says as a data controller first, but they are contractually engaged by the UWI to provide health insurance services to you, and therefore we need to process on behalf of the university your information so you can have access to health insurance. So one of the key elements that I try to share with everyone on this particular point is that all persons or public authorities are data controllers first, and it's your contractual arrangement that will determine primarily if you become a processor. And I've heard some persons coin this term sub-processor because there's a third party involved in processing the data shared between you, the subject, and the person with whom you're actually doing business, whether it be an institution or an individual or a public authority. So it's that third party or third person processing that takes place that distinguishes a processor from a controller. Both must comply with all the processing standards. They both must comply with reporting a breach. And the important part of it is that their contractual agreement must state how liability will be apportioned should something happen that wasn't planned for.
Thank you. So the data controllers, they are required to comply with the data protection requirements, the laws, regulations that come out of the Office of the Information Commissioner. Now, what does the Office of the Information Commissioner look for when assessing compliance of our data controllers?
All right, I'm not going to repeat most of what Dr. Anglin says, but you can certainly appreciate from all of our comments thus far that there are international best practices. So it's not just our local legislation, but it's how do we protect information belonging to you, to your family, to the person sitting next to you in a way that allows for your business to be facilitated, but the confidentiality, integrity, availability, and the resilience of how your data is actually managed by data controllers are kept in the state that it ought to be kept. So when you talk about compliance, there are complex, it can be very complex and it can be very simply viewed. At basis, what we look for is that there's a structured governance framework. So you would have heard Dr. Anglin talk about the structured approach, having the 6 streams, and then moving into another phase to intensify, to deepen, to further entrench and build that privacy sensitivity across the 26 jurisdictions. And remember, in the 26 jurisdictions, it may not even be the same because each society would have different classifications for personal identifiable information. So, for example, financial data is deemed sensitive personal data in some of the Eastern Caribbean countries where that's not so for us here in Jamaica. So when we're talking about compliance, it's looking at how have you examined how you do things, what have you put in place. So practices such as privacy engineering, which is just another way of saying we're looking at how we do everything that we do to make sure that we're not exposing ourselves to the risk of having a breach or an incident that compromises the protection that ought to be afforded your personal data. So it's a holistic approach. I know when you speak to our offices, our office or our officers, they'll probably tell you 5 basic things. Register with the office. If you're required by law under Section 20 to appoint a data protection officer, do so, and do so so that you can actually be compliant and that the person can help you to do what you're expected to do better. There are many different ways that can happen, because sometimes the data protection officer is also handed the privacy program management. There are 2 separate roles, and depending on your context and the size of your operations, they may have to be merged, but just to point out, the legislative function will always take priority over anything else. So in much larger organizations, you may have a whole company that does DPO services and as chief privacy officer, who is the point person to coordinate the internal committee that will manage a structured approach to privacy. It's also, I mentioned privacy engineering, so we have 2 terms that you may hear from all of us here. Privacy by design, where for every new process, you look to see where am I exposed in terms of processing personal data. You build your program, your process, your procedure, your SOPs, everything to close that gap as much as possible. But then you were already operating before the act came into effect in 2020. So you also have to do privacy by default, revisit what happened before, and plug those areas of exposure, those gaps. So it's a holistic approach when we come in to examine. As I said, there are 5 things that we normally tell persons: register, appoint your DPO, comply with all the standards, make sure you report any incident, because an incident is not a breach all the time. There may just have been something happening, but it's important for you to make the report, and then once you've completed your investigation and your assessment, you can send subsequent reports so we have a whole picture of what has happened. And I think the last thing is, most importantly, is to do, especially for larger data controllers, to actually take a planned approach to the change and culture management, to change the mindset of staff and the circle of data subjects you interact with and serve. So, for example, you're focusing on vendors and partners. So that's one set of data subjects. You have students here at the university. That's another category of data subjects. Because you're a tertiary level educational institution, these are considerations which come with their own risk exposure, which will be very different from an investment firm or someone who is providing ICT services. So it has to be tailored, but you have to understand what it is that you do, and then you have to communicate that across the organization, because most of the breaches that I have to deal with come because somebody didn't understand that by sending the wrong email to someone with someone's personal data, you've created 2 victims of a single breach. They know that the person whose information was shared is victim number 1, but they forget that the person who actually received it is also impacted and needs to be counted. So it's looking at how you have approached integrating the law, international best practices, and practices that suit your sector and industry, which we continue to work with our stakeholders to develop guidelines to assist further. We're still a bit away, but we continue to work to do that.
Thank you. I hear you mention some things that you do as a regulator. You look at compliance, you look at registration of the data controllers, you handle breaches, but what is the primary goal of the OIC as a regulator?
Well, the primary goal is to enforce the Act. It's that simple. However, Section 4 of the Act actually details quite a bit of information, in particular subsection 5, which talks about monitoring compliance, advising government and others, and then there are about 4 or 5 paragraphs under that subsection 5 which talk about advocacy, promulgation of the information, ensuring that people are aware of what their rights are. And then there is my favorite part, which talks about partnering with persons so that we can have a better understanding of what you do and create guidelines for compliance that actually are practical and workable. So in essence, we are the bridge that holds the subject, because we help to ensure that your rights are actually protected, because you can you can seek redress from us and not just the courts. And by the way, that section 68 that Dr. Anglin alluded to, I enjoy section 68 and section 69 a lot. So let me just have my one moment of indulgence. So just so you know, liability under the Act accrues not just to an organization under Section 68, where you can be fined by the court up to 4% of your annual worldwide turnover, your gross annual worldwide turnover. So you're operating in 26 different jurisdictions. How much profit you made over the 1 year? And the court can make a judgment up to 4%, but Section 69 provides that individual officers of the organization, the data controller, because we're at UWI, I'm going to keep it at the legal personality level for today. They can be individually fined. So your principal, your registrar, actual officers, yes, even the secretary, if you are found that your particular action was so culpable that it rises to the level of criminal prosecution, you can be personally liable, and that's when the terms of imprisonment or fines personally apply to you in addition to the organization. Now, although I enjoy saying that, that's not what we want to emphasize at the OIC. What we want to emphasize is that persons need to know what their rights are, so they're empowered to act, not just in Jamaica's jurisdiction, but understand when they cross borders, they still maintain that right to privacy for their personal data. The legislation may be a little different, as I pointed out, that financial information in the Eastern Caribbean based on their core business is a little different and thought to be sensitive personal data. But at the end of the day, that's what we do. We're the bridge to protect your rights. We're the bridge to assist data controllers in good, steady practices that will protect the personal data while being processed. And then we also have our own role as a government entity, a government authority, which we also have to comply, because we must first lead by example.
And I'm happy for that. Can you please give Miss Holness a round of applause? Thank you very much for those answers that are very detailed, and I appreciate the effort that you have made to explain in layman terms so we can understand. Thank you very much. Now to Chris and Charles. Miss Sandra, welcome. In a previous question that I had asked, you explained that Chris and Charles is an investment company and you collect personal data to process loan applications, and it's a requirement of your operations. There may be instances where you have to engage a data processor to assist with some of your activities. When using a data processor, what processes are in place to ensure that personal data is safeguarded?
Okay, I'm just going to use the fact that we have artists here and they are really one of our sub-processors. Oh, sorry, I hope you heard that. Sorry about that. So Vertis, they are one of our sub-processor, because they are our, in terms of our VDI, which is our Vertis, our space, which is our virtual space, sorry about that. Then we have to interface with them. So at all times, we have to ensure that we have a contract with them. Now, the contract that we have, also there is a data processing section agreement that we have with them. So we have to ensure that in that document, we are ensured that our data is safe. So what are the safeguard that you have in terms to protect our data? Should we give our data to you? So we have to ensure that is in place. We also look at the agreement in terms of confidentiality, because we have to ensure that this company is a company that when our data goes to you, then we know that the confidential information is going to remain confidential. And also is that we ensure that, we check our internet space, our social media space, to see if there are any breaches in terms of Vertis, because we want to see what is out there. Are they also, we also ensure that they are a controller and that they are registered, because if they are not registered, then we can't do business with them, because then we are going to be breaching the Data Protection Act. And so we ensure that they are. So there are these, some of these things that we look forward to when we are engaging a sub-processor.
You would have assessed the trustworthiness of a processor before you engage them. How do you do that? How do you know that your processors are trustworthy?
One of the first things that we'd normally do is we ask for a contract, and within that contract space, we would ask for testimonials. So we want you to give us some organizations that you have worked with before, so that we can also do, and we get consent, by the way, so I'm making sure that we can, right? So we get consent to, do our own research to call this company, just for, to find out whether or not I'm using Vertis, whether or not it's a company that we can do business with. So we'll get the testimonials from them. So that's one of the things that we will do. Also, we ensure that, they have the proper security in place. So we'll ask for documentation to see what kind of security that they have in place. And, to see whether or not it's a company that they take care of and that they are also guided by the Data Protection Act. So we'll ask for documentations for those of which we will get. And if we are not satisfied, then we will also ask them to, just to, in terms of signing a contract, to say what is it that you will give us as a company in terms of data protection, protecting our data, ensuring that they are private, ensuring that, whatever it is, when you go into that space, we know for sure that we can trust you, that whatever you say you will deliver, you will deliver. So they have to sign all of these documents for us. So we take all of these into consideration.
And my final question to you, Ms. Robinson. As a data controller, how important is it to have data protection and privacy policies implemented throughout Chris and Charles?
That is very, very important, because one of the things is that I think what is happening with a lot of organizations is that persons somewhat don't see data protection as something that we have to pay attention to right now. And so you need policies. You have to change the culture of the organization. So, and changing the culture is going to require policies. And not just policies, but procedures. And then at the same time, while you do that, is that you have to allow them to understand. So there must be an awareness session, there must be training. So it is important that because the policy would include training and, all the different elements of the data protection. And so we will have different sessions so that at the end of the day, they understand their responsibilities as an employee. They also understand the responsibility of the organization, understand if they breached the policy, what can happen. And just a while ago, we were told by our OIC representative. And so they will understand that there is a need for us to adhere to what the policies are saying, because this is what will guide the organization to be effective in its operation, and that we do not have problems with OIC at the end of the day.
Miss OIC. Thank you very much for your responses, Miss OIC. Your name I call like, wow. But I'm happy that you're aware of the OIC's requirements, and you're doing whatever it is necessary to ensure that you're in compliance. Please put your hands together for Mrs. Robinson. Now, Vertis, you are a processor for Chris and Charles. Now, Since the implementation of the Data Protection Act, and now you are now aware of the requirements under the Act, are there any safeguard mechanisms that your organization has implemented since the Data Protection Act came into effect?
Okay, so yes, so since the Data Protection Act came into effect, we would have implemented, not just within our organization, but by extension our clients, we would have enforced things like multi-factor authentication, data encryption, server encryption, role-based access, and things of that nature, just to ensure that not just maintaining privacy as a concept, but implementing privacy as a practice. So you don't have access to data that you don't need to have access to. And that is where role-based access comes in. So as an accountant, you don't need to have access to HR records. You only need to have access to financial records. As IT personnel, your domain is the IT infrastructure. So you need not have access to the financial records of the company. You may manage the server that the data sits on, which is where Vertis comes in. We manage a lot of servers and infrastructure for our clients, but we don't necessarily touch or see the personal data that sits on these servers. That is where encryption comes into place. So while we process data, as Mrs. Robinson Brown would have stated, we're sub-processors. We don't necessarily touch or read the data that sits on these servers. We maintain the environment and ensure that it is in compliance with not just local but also international regulators, and ensuring that it stays compliant, and by extension it makes our clients compliant as well.
Wow, thank you. I'm happy to know that you are doing all those things to ensure that Chris and Charles and your other clients' data is protected. Mrs. Robinson Brown would have mentioned that one of the things that they would have done to engage you as a processor was to have you sign an agreement. Now, what is a data processing agreement, and what does this agreement mean operationally?
All right, so operationally, the DPA specifies and outlines the clear objectives and the clear roles that Vertis and our client play in data protection. So it will outline that, okay, Vertis is in charge of maintaining and operating the IT infrastructure. So what that means is that if there is any evidence of a breach, and when I say any evidence, if it even means that for whatever reason a password has been leaked to an unauthorized user, we need to ensure that we contain that leak. We also need to ensure that we inform our clients that, hey, we had this incident, this is what we did to contain it, and then by extension, our clients will now be able to make their necessary reports to the OIC to say, hey, we had a data breach, or third-party operators would have contained the breach and confirmed that the breach is no longer a threat to our organization, and these are the things that we would have done to maintain the environment thereafter. So the DPA clearly outlines who is responsible for what, where our roles lie in the incident management of a breach and any other incidents that may happen. It doesn't, as Mrs. Holness stated, not every breach is not every incident is a breach, right? So in the incident management process, it outlines it outlines what Vertis is responsible for, and then by extension what our clients are responsible to do thereafter.
Okay, thank you very much. Ms. Holness, I just want to bring you in for just one comment as it relates to the processing agreement. Is there any, just give me one additional thing that Mrs. Masters would not have mentioned. For example, I know she spoke about breach management as part of the agreement. Can you give me another feature of an agreement?
All right, so one of the perceptions that I hope no one listening today leaves with, the Data Protection Act is part of a wider legislative framework that governs how persons are to live within particular societies. It operates in conjunction with other laws. So for the data processing agreement, while the substance and the objective or the object of the agreement really looks at how are we as controller, data controller as one party, as data processor as the other party, going to manage the shared responsibility for full compliance as we process personal data, one on behalf of the other. However, that is still an agreement. So the laws of contract, or the principles that govern contract management, and when parties agree to something, operate, albeit that you are dealing with the core business of compliance with the Data Protection Act and how you will apportion most persons' focus on liability. But all the other rules of contract would apply. So one of the messages that my office is certainly sharing is that we need to contextualize where the act falls, what it means in practical terms, and that you don't have a situation where you forget the other legal principles that may apply. So it is still a contract. It still is binding on the parties as they have signed it. Each party has the same negotiating power and influence, because we have found from feedback that the data processors often find or feel that they're not the equivalent in influencing the final agreement, because they look at it as a client and supplier, where the supplier is not in a prime position. That is not how the agreement ought to operate. It's still a contract. Both parties must ensure that they understand what they have agreed to and that there was a real meeting of the minds. So a data processor can, in keeping with the 7th standard, which looks at most of our discussions have been about what one needs to do to comply with the 7th standard, which talks about having appropriate technical and organizational measures in place to ensure the protection of the personal data being processed. The processor can tell the data controller, your systems are not up to the level that will assure us the kind of stability and offer us the room to preserve the information that we are processing, and ask that the controller updates their measures and technical, whether it be technical or organizational mechanisms before entering into contract, because they do not wish to expose themselves to litigation or any other cost exposure because the controller has not done their part. So I think that point, it's an agreement, the law of contract applies, each party has similar rights, and they need to make sure that they're not entering into an agreement which is binding, save and except that statutory law would override it. Before, say if you go before the courts, you have the same right, because the law of contract also applies.
Thank you, Ms. Holness, for that clarification, because at some points, some people may believe that the contract is one-sided, but I'm happy to hear that it is both parties that have right. Thank you. Dr. Anglin, I see you want to say something.
Yes. I think a critical bit, which I didn't hear, so I'm going to add it. What happens at the end of the engagement between the processor and the controller? That is critical. that personal data, because remember the definition of controller is the entity or the person who determines how the information is processed, right? And the purpose. So therefore, at the end of the agreement, all the information which would have been processed by the processor should be returned to the controller, and they should keep none of it. Now, of course, there are instances where the processor might have developed a relationship with a client outside of the controller processor engagement, which again would be determined by the contract. But I just want to make the point, especially using the health insurance example, at the end of that contract period, the information that was sent to the processor should be returned and any remnants of it be removed from their systems. That is important.
Thank you very much.
Including what is in the cloud.
Oh, yes, because we have a lot of cloud-based storage solutions, and I'm sure that we don't want the clouds to be raining people's personal data. We don't want any thunderstorms and showers of personal data. Mrs. Robinson Brown, you want to make a comment?
Are you hearing me? All right, I just wanted to add that sometimes the process between the controller and the sub-processor can be so difficult because the data controller, yes, sometimes it's so difficult because sometimes there's a back and forth because the sub-processor sometimes thinks that what we have is okay. But you see, when you have a good data protection officer in place as a data controller, then we always have to stand our ground because we have had experiences like that and like back and forth, and the sub processor was saying that this is okay and they are not changing, and we're saying, well, we can't do business with you, and so we keep on getting that back and forth until they have to say, okay, we will go with it. So the process can be long, but ensure that at the end of the day, it doesn't matter what. Don't move away from what the Data Protection Act is saying, and make sure that, and use your exit clause, yes, to ensure that you have what it is that you will move forward with. Thank you.
Thank you. And that is why it is important for us to engage the University Data Protection Office as a DPO for organizations, because we have the expertise, we have the know-how, and we have the person, Mr. Dr. Patrick Anglin, who will ensure, and the team, who will ensure that when engaging our sub-processors or our processors, they meet all the requirements to ensure that the data controller is protected. Thank you, Mrs. Masters. Thank you, panelists. Please give Mrs. Masters a hand. That question was very, very interesting. All right, I'll ask one more question. We only have a few minutes, so I'll ask one question to any member of the panelists. Now, how does poor data handling affect an organization's reputation and public trust?
Okay, so it affects, I'm going to use again Chris and Charles. So because we are in the investment lending business, so we invest. Now, if we have issues, then what happens is nobody will want to engage us. So you lose that trust. So even our customer, you can see our persons just don't want to do business with us anymore. So if our customers, because if out there they cannot trust us, they realize that this is not an institution that we can trust. This is an institution that my data might be out there because they did not do the required things that they were supposed to do, and so it can affect us financially. we might be charged, as we mentioned earlier on, by going to court. So we can be fined. There can be legal implications, and so is that we have to ensure that we stay within our bounds so that we don't have our reputation being affected. It can really affect our financial. Bottom line, the profit margin can go down because no longer we have the amount of customers that we target on a yearly basis, because they will move away. Potential customer will say no.
Dr. Anglin?
Yes. Importantly, I think we have to recognize something. We operate in a global village. For those who didn't realize, we operate internationally, even when we're not home. And therefore, the persons with whom we do business sometimes reside in other jurisdictions. And some of these jurisdictions are very mature in respect of their privacy practices. And they look at us negatively, and that translates into loss of business too. But not just loss of business, but loss of reputation, and reputational damage is a big thing. Now, I'm going to harken back to something that Ms. Holness said. She mentioned about financial data being sensitive in some jurisdictions and not in others. Well, as an organization, because we recognize that we operate in so many different jurisdictions, what we did was we benchmarked our policy on the most stringent operational requirements. So therefore, financial data at the University of the West Indies is considered sensitive. Some of the rights, for example, portability, which is not necessarily clear in our jurisdiction, is actually enforced at the university. So what we have done is we recognize that we are multi-jurisdictional, and we have to ensure that you can operate in the university in whichever jurisdiction. So, for those of us who are not in Jamaica, we don't expect you to be experts in the law. We don't expect you to be legal scholars. So we have come up with a policy which is all-encompassing, which covers all our jurisdictions, and all we say, look at the policy, and you're in compliance if you follow it.
Thank you, Dr. Anglin. Mrs. Masters?
And just to add a real-life example of how your reputation can be affected. You may be aware that there's some international stores or outlets that you can't use your Jamaican cards with, right? That is simply because the amount of data breaches that a particular bank may have on a yearly basis affects their position to international compliance regulators as well. And so you'll see that you may not be able to use a certain blue bank card, but you're able to use a certain red bank card, right? You're able to shop on a certain platform with a certain card, but you're not able to use a different card on the same platform, even though both of them are in Jamaica. And this is just simply because of their reputation, how it is viewed, not just locally. So you have to understand that the reputation is not just in Jamaica, it's on a global standpoint. And so you have to ensure that everything that you're doing, even as a data subject, you have to also hold that responsibility and hold your data processors and data controllers accountable for how they manage your data, because you being able to use your card should be the baseline, right? You should not be inconvenienced, or you should not have to go to another institution just to be able to have the same access to resources as another person.
Thank you very much, Mrs. Masters. That's a very personal and practical example that, I know many of us who shop on Amazon and Shein and the new Temu and all of that, would have experienced in some way, shape, or form having not been able to use your cards online. So thank you for that example. Yes, Miss Holness?
Just want to add to what everyone has said. These global statistics are that 87% of everyday citizens, you and I, determine if we're going to continue doing business with data controllers. And earlier, I think there was an allusion to self-reporting, and persons think by covering it up. When you talk about trust and reputational damage, you're actually trading in a currency that once lost cannot be regained sometimes. And it's not it's not if an incident will happen, but when. Because of the various actors across the digital ecosystem in particular. So it's important that you don't look at compliance, because everybody basically beat my office just now to say we don't wish to be in breach of the act so that our office comes. But look at what it means to you every day. There's a dark history to why this has come, where your personal data as a citizen in your country can be used to track you, and not only track you, move you to spaces, and eventually be used to, shall we say, have you say goodbye forever to the rest of us. That's where all of this is coming from. So when you're talking about reputational damage and public trust and confidence, consistency in your compliance efforts, being very clear, having an actual plan for communication when there is an incident. I cannot underscore how important it is to have a proper program and an approach. And don't look at compliance as, oh, you have to follow a bunch of rules. Look at what the cost will be, including your business never existing anymore, because you have lost trust, because you were not compliant, you were not consistent, you were not transparent, you were not accountable. And at the end of the day, as the regulator, we want to ensure that any data controller who puts your personal data at risk is held accountable, and if needs be, operates no more. Because at the end of the day, we're protecting people, not just their information. Thank you.
Thank you very much. And we did not roast any yam, we did not roast any corn, we did not have any s'mores, but we had a full plate, a 3-course meal. We did 4 or maybe 5. And the meal was scrumptious. Thank you very much, Dr. Anglin, Miss Holness, Mrs. Brown, Robinson Brown, and Mrs. Masters for this wonderful fireside chat. And now I'll hand over to Mr. Shane Morrison. Thank you.
Thank you so much, Mrs. Facey. Let's give them a hand again. They were wonderful, weren't they? So I will invite Mr. Cleon Cadogan from the University Data Protection Office. He'll give the official vote of thanks to our panelist and moderator.
Thank you, Ms. Morrison. Good evening, everyone. Thank you is a must. Thank you to our able moderator, Mrs. Gayan Facey, for engaging the panelists today. Thank you to Mrs. Cassandra Lee Masters from Vertec, Ms. Andre Holness, Mrs. Sandra Robinson Brown, and the Thorn that was making certain that you paid attention to the beautiful roses, the one and only Dr. Patrick Anglin. Ladies and gentlemen, I want you to put your hands together for them this evening. This would not have been possible without the brainstorming of our team, Ms. Masters, and the other colleagues of our department. To you, our stakeholders who stood the test of enduring, listening to the information that you will share with your other colleagues, thank you. On behalf of the University Data Protection Office, feel free to follow our page, and feel free to remember that your data is important to you. Have a great evening.